All right, let me call this matter. This is the time and date for the hearing in the two matters of Township of Lockport versus Anthony Mayer. File numbers are 242069ON. O stands for ordinance. File 251880N. The township is represented by David Szymanski and Trent Cunningham. The defendant is present. He's represented by attorney Ross Truckee. There are two tickets which have been formalized with a formal jurat. File 251880N alleges, this copy, it's hard to read, violation of section 951401 of zoning ordinance, including section 9495.402. That violation is alleged to have occurred January 31st of 2025. The earlier citation is in 242069. Read these copies. Which is alleged to be continuing violations of vehicle storage and repair ordinance. We've spent a lot of time on this matter. We were set for hearing earlier on May 27th, I believe the day was. Mr. Truckee had filed an appearance and asked for an adjournment. The matter was set for hearing on these matters today. Good morning, gentlemen.
Morning.
Morning. Everybody ready to go?
Yes.
All right. I did, and I appreciate the paper copies. Everything is scanned into OnBase, so it's in my computer, but I'm old and I'm used to looking at paper things. So I do appreciate that. Who's going to speak on behalf of the township?
I will, Your Honor.
All right. Are you ready to proceed?
Yes, Your Honor.
All right. Why don't you go ahead and place your appearance on the record?
Trent Cunningham on behalf of Lockport Township. We'll just proceed with the opening, Your Honor.
Yes.
All right. Good morning. Today I'm before you to prosecute two violations of Lockport Township's ordinances, as this court is aware. The ordinances, as Your Honor just recounted, relate to violations of the vehicle storage and repair ordinances, as well as violations of the zoning ordinance that have taken place on Mr. Mayer's property at 17342 Birchleaf Court. Today you'll hear testimony from the Township Zoning Administrator and Code Enforcement Officer, Doug Coleman. Doug will explain how the conditions on Mr. Mayer's property violate the Township's ordinances. He'll testify to the conditions on the property as of the date that both citations were issued and show pictures of the property as he observed them on those days and then thereafter. Mr. Coleman will also show that the vehicle storage and repair ordinance, which is also referred to as Ordinance 99-11A, prohibits the storage or parking of commercial construction equipment, and it may only be parked on the property if there's an active building permit in effect. Mr. Coleman will testify that 17342 Birchleaf Court is in a platted subdivision, the North Meadows subdivision, and is zoned residential, as well as the fact that there is no active building permit for the property, that there was not an active building permit for the property when the citations were issued. The equipment parked and stored at 17342 Birchleaf is commercial construction equipment as defined in the ordinance, and thus it cannot be parked, left, or stored on the property without a valid building permit. Even if there was a valid building permit, the equipment could only be stored there for the pendency of that permit and only the equipment that's necessary for the construction under the plain language of the ordinance. In addition to the impermissible construction equipment, Mr. Coleman will also show that there's a large camouflage semi-truck on the property, which would constitute a commercial motor vehicle under the vehicle storage and repair ordinance. And this does not meet the requirements for storing or parking a commercial motor vehicle on the property, as Mr. Coleman will show. As for the zoning violations, Mr. Coleman will show that by a preponderance of the evidence that the equipment stored and used on the property is also used in connection with Mayer Builders, which is the construction company owned and operated by Mr. Mayer. Accordingly, this is conducting an unauthorized commercial equipment storage occupation or home occupation, which is an impermissible it's an impermissible home occupation under the zoning ordinance. The commercial construction equipment storage does not satisfy the zoning ordinance requirements for a valid home occupation. In other words, the zoning ordinance does not allow a residential property to be used for commercial equipment storage. As defined in the zoning ordinance, a valid home occupation must be conducted completely indoors. The ordinance says, quote, confined completely within a dwelling, which is clearly not the case here, as the equipment is in the yard and is not stored within a building. Additionally, the conditions on Mr. Mayer's property violates the off-street parking requirements in the zoning ordinance, which is section 95.1402C. These provisions regulate the parking of motor vehicles in residential zoning districts. And Mr. Coleman's testimony will show that the semi-truck does not satisfy the requirements for permissible off-street parking of motor vehicles. Specifically, section 95.1402 allows not more than one commercial vehicle of a light delivery type to be stored on the property. And Mr. Coleman will show through his testimony that the green camouflage semi-truck is not a commercial vehicle of a light delivery type. And therefore, parking the semi-truck outside or in a residential yard is prohibited by the zoning ordinance. In addition to Doug's testimony, you'll also hear testimony from Sherry Nowicky, who is a neighbor to Mr. Mayer and has been a realtor for 31 years. She will testify to her experience as a neighbor and how the conditions on the subject property have impacted the neighborhood. And then, given Sherry's extensive experience in real estate matters, she's also prepared to testify about how the subject property impacts potential property values in the surrounding neighborhood and how it could impact potential home buyers in the surrounding neighborhood. Now, there's been a lot of claims so far in these proceedings by Mr. Mayer related to FOIA requests, related to ex post facto enforcement, and related to grandfathering. We're prepared to address these legal claims throughout the proceeding as they arise, but just to briefly address them now, these claims are red herrings. It is true that Lockport Township amended the vehicle storage and repair ordinance to address these types of issues of commercial vehicles and commercial equipment being stored on residential property. This is common for townships and governments to amend their regulations to address a regulatory need that arises. Governments commonly amend regulations for new and emerging public health, safety, and general welfare issues. This was not an effort to target Mr. Mayer. And in fact, the township sent Mr. Mayer a letter after the amendment was implemented and in effect. And this letter gave him time to voluntarily comply with the new requirements that were lawfully in effect at the time. He refused to comply and remove the equipment, which has led us to this point. So along those lines, I just want to briefly address the claims of grandfathering. The vehicle storage and repair ordinance is a police power ordinance, not a zoning ordinance. Grandfathering does not apply to police power ordinances, and there's clear public policy reasons for this distinction, and it's well settled within Michigan law. Take, for example, regulations on speeding. If a roadway has no speed limit and the government identifies this issue and deems it a risk to the public safety and welfare, the government could then implement a speed limit. If after that law was passed implementing a speed limit, a person continues to speed down that roadway, it would not be a defense to then claim, Your Honor, I was speeding down the road before this regulation was in place. The same concept would apply here with the police power ordinance, the vehicle storage and repair ordinance. The township identified an area where regulation was required to protect the general welfare of its residents, and in response, it amended the police power ordinance to implement those necessary regulations. The Michigan Supreme Court has explained that there's no grandfathering or non-conforming uses for police power ordinances in Adams Outdoor Advertising v. East Lansing, which is 463 Mich 17. In that case, the court acknowledges that the sign code at issue in Adams was a police power ordinance and not a zoning ordinance. And the court goes on to state that accordingly, non-conforming use analysis is inopposite here. To understand this distinction, that non-conforming use analysis applies only to zoning regulations and not to public health and safety regulations, one need only consider the unprecedented handcuffing of the government that would ensue if public health and safety regulations were subject to non-conforming use analysis. This would leave governments powerless to immediately terminate existing hazardous or dangerous activities because any pre-existing facility engaged in those activities would be able to claim non-conforming use status and continue indefinitely in spite of the regulations. That's Adams Outdoors versus East Lansing. So the Michigan Supreme Court was clear that non-conforming use analysis and grandfathering does not apply to police power ordinances. Accordingly, the vehicle storage and repair ordinances as amended in July of 2024 would apply to the subject property and the activities conducted on the subject property, including the parking and storage of commercial vehicles and equipment. Moreover, as we will show, the conditions of Mr. Mayor's property also violate long-standing zoning violations that were applicable to the property and were in place long before the citations were issued. At the conclusion of this, I will ask this court to find the defendant responsible for violating the township's vehicle storage and repair ordinance, as well as the zoning ordinance. I'll ask this court to require the defendant to pay the corresponding civil fines and issue an injunctive order requiring the defendant to abate the violations on his property. If the defendant fails to comply with this injunctive order, we would ask that the township be authorized to abate the violations without further court proceedings, with the cost of such abatement being charged to the defendant and ultimately resulting in a lien on the property if the costs go unpaid. In addition to that, we're prepared at any point throughout these proceedings to address the issue of costs that arose at the previous, the adjourned pretrial, as this court is aware, and as we filed a bill of cost along with our stipulation to adjourn. And so we're prepared to address that cost argument whenever this court or your honor would like to address that issue as well. Thank you.
You can do that at the close and remind me if I forget. Thank you. Mr. Truckee, do you wish to make any opening at this point? Or
I reserve.
All right. All right, you may call your first witness.
Thank you, your honor. The township would call